You know, in the financial world, when a legal defense structure that has been carefully constructed over months suddenly collapses within hours of new evidence becoming public, it signals something far deeper than routine litigation setback. That's exactly where we are right now, with the complete disintegration of Donald Trump's legal team following what sources are describing as a catastrophic evidence leak. From an investor's perspective, this is less about courtroom tactics and more about institutional signals. Signals about the strength of evidence, the sustainability of defense strategies, and the internal fractures that emerge when legal professionals face ethical dilemmas that override client loyalty. You see, structural collapse doesn't happen gradually in well-managed organizations. It happens suddenly when accumulated pressures exceed the load-bearing capacity of the framework holding everything together. And that's what I want to talk to you about today, because this development matters to every American who cares about accountability, transparency, and the functioning of our justice system. Before we proceed further, if you find this kind of independent analysis valuable in understanding events that shape our national trajectory, please take a moment to like this video and subscribe to the channel. Your support enables us to continue providing this perspective on developments that affect all of us as stakeholders in American democracy. In my 94 years, I've witnessed countless legal battles involving prominent figures, corporate executives, and political leaders. As someone who has observed both capital markets and legal systems for over half a century, I can tell you this with absolute certainty. When experienced attorneys abandon clients in the middle of high-stakes litigation, particularly when those departures occur en masse rather than individually, it reflects a calculation that continuing representation poses greater professional and ethical risk than the reputational cost of withdrawal. You see, markets teach you that sudden exits reveal information that slower processes might obscure. When multiple professionals who have invested significant time and resources into a case simultaneously conclude that continued involvement is untenable, they possess information or face pressures that have fundamentally altered their risk assessment. In business, we have a saying that rats don't leave a seaworthy ship. The legal profession operates under similar logic. Attorneys don't abandon lucrative, high-profile representations unless staying poses threats to their licenses, their reputations, or their ethical standing that outweigh every incentive to remain. Now, I'm not here to prejudge legal outcomes or to suggest that attorney departures prove client guilt. Let me be frank about something important. I believe deeply in the adversarial legal system, in every defendant's right to vigorous representation, and in the principle that legal professionals serve crucial societal functions even when representing unpopular clients. But I also understand that the legal profession operates under ethical constraints that sometimes create irreconcilable conflicts between client loyalty and professional obligation. When those conflicts emerge and attorneys choose professional survival over client representation, it tells us something significant about the nature of the evidence they've encountered or the client conduct they've witnessed. What happened over the past 48 hours represents a collapse of such speed and completeness that legal observers across the ideological spectrum are expressing shock. You see, legal team departures in major cases typically unfold through managed transitions, where departing attorneys help secure replacement counsel and ensure continuity of representation. The conversation in legal circles has shifted from routine discussion of trial strategy and motion practice to crisis analysis of how such comprehensive structural failure could occur so rapidly. New evidence that leaked to media organizations over the weekend apparently revealed information so damaging that attorneys who had publicly defended Trump's innocence for months concluded they could no longer do so without violating ethical obligations or risking their professional standing. From a risk management perspective, the concern lies in the convergence of multiple institutional failures simultaneously. Attorney-client relationships breaking down on one side, evidence security protocols failing on the other, and a complete breakdown of the confidentiality and trust that legal representation requires. In corporate terms, it resembles discovering that a company's auditors have resigned en masse after uncovering accounting irregularities they cannot reconcile with professional standards. You see, you don't witness that kind of wholesale abandonment unless the underlying situation has deteriorated beyond what normal professional relationships can accommodate. But what followed the initial attorney departures was even more revealing from an institutional perspective. Within 12 hours of the first resignations becoming public, additional members of Trump's legal team announced their withdrawal from the case. You see, these weren't junior associates or peripheral advisors with limited investment in the litigation. Reports indicate that senior partners who had served as lead counsel, attorneys who had appeared in court and filed major motions, and legal strategists who had been central to defense planning all concluded simultaneously that continued representation was impossible. In any professional services context, when multiple senior practitioners abandon a lucrative engagement simultaneously, it indicates either catastrophic client misconduct that makes continued representation unethical, or evidence developments that make previously maintained positions legally untenable. You see, this suggests that the leaked evidence fundamentally undermined defense theories that attorneys had advanced in court, creating potential exposure for having made representations to judges that new evidence contradicts. These aren't inexperienced lawyers prone to panic under pressure or opportunists seeking better clients. The attorneys departing Trump's legal team include individuals with decades of experience in high-stakes litigation, attorneys who have represented controversial clients throughout their careers, and legal professionals who understood from the outset that this representation would attract intense scrutiny and criticism. When practitioners of that caliber and experience simultaneously conclude that continued representation poses unacceptable risks, you see, the professional fabric supporting the defense has completely torn. The kind of tear that occurs when the gap between what attorneys told courts and what evidence actually shows becomes impossible to reconcile through any combination of legal argument or factual interpretation. What's unfolding is historically extraordinary in American legal practice, and I want to be precise about why this matters beyond the immediate case. You see, we're witnessing the complete collapse of legal representation for a former president facing multiple criminal charges, not because attorneys cannot be found or afforded, but because attorneys who previously committed to the representation have concluded that continuing violates professional obligations they cannot ignore. That's not normal litigation development. That's a crisis that reflects profound dysfunction in the attorney-client relationship and potentially serious ethical dilemmas created by client conduct or evidence developments. It demonstrates that even in the most high-profile representation imaginable, professional ethics and legal obligations ultimately constrain what attorneys can do, regardless of client preference or political pressure. You see, in legal systems built on adversarial representation, when even defense attorneys conclude they cannot continue representation, it signals something deeply troubling about either client conduct or evidence strength that makes vigorous defense impossible within ethical bounds. This moment carries extraordinary weight because it represents the intersection of legal ethics, criminal procedure, and political consequence in ways that American jurisprudence rarely confronts so visibly. The legal profession depends on attorneys being willing to represent unpopular defendants and advance aggressive defenses within legal and ethical boundaries. When those boundaries prevent continued representation in a case of this magnitude, the system itself faces stress. You see, if Trump cannot maintain legal representation despite possessing resources to pay any attorney willing to take the case, it suggests that professional considerations have made this representation effectively untouchable regardless of compensation. That creates serious questions about whether adequate representation remains possible, questions that could affect case proceedings and potentially grounds for appeals if representation quality suffers due to attorney unwillingness rather than client inability to afford counsel. This situation is without clear precedent in modern American legal history, not because prominent defendants have never faced attorney departures, but because the combination of comprehensive team collapse, apparent evidence-driven crisis, and the political stature of the defendant creates circumstances that existing professional frameworks struggle to address adequately. You see, when Richard Nixon faced legal jeopardy, he maintained legal representation throughout because attorneys concluded they could ethically defend him within bounds of professional responsibility. When other political figures have faced serious charges, they've experienced individual attorney changes but not wholesale team dissolution. This is different. This suggests either that the evidence leaked is so conclusive that defense becomes professionally untenable, or that client conduct has created ethical conflicts that make continued representation impossible regardless of evidence strength. Either explanation points to circumstances far outside normal litigation parameters. For a legal team to collapse this completely, and this rapidly, suggests that the leaked evidence contained information attorneys had not previously possessed, or that fundamentally contradicted information clients had provided. You see, legal ethics allow for vigorous defense of guilty clients, but they prohibit attorneys from advancing arguments they know to be false, or presenting testimony they know to be perjured. If leaked evidence revealed that defense theories attorneys had advanced in court were contradicted by documentary proof, or that client representations to counsel were materially false, continued representation might become ethically impossible. As someone who has reviewed countless litigation strategies and risk assessments over decades, I can tell you that evidence developments compelling enough to trigger mass attorney withdrawal must be extraordinarily damaging, not merely unfavorable, but fundamentally destructive to defense credibility in ways that make continued advocacy impossible within professional constraints. Amid all the political commentary that will inevitably surround this development, one thing becomes clear to me as someone who has spent a lifetime evaluating institutional behavior and professional decision-making. You see, it's increasingly important to distinguish between what various political partisans claim about these events and what the behavior of legal professionals actually reveals. In business, we don't rely on what marketing departments claim about product quality. We examine what independent experts conclude and what actual performance data demonstrates. The same analytical discipline applies here. What matters is not what Trump supporters or critics assert about attorney departures, but what those departures themselves signal about the professional judgments of experienced attorneys with access to evidence and client interactions that the public cannot see. The decision of multiple seasoned legal professionals to abandon lucrative, high-profile representation simultaneously tells us something important. It tells us that people with more information than the public possesses have concluded that continued involvement poses risks that override every professional and financial incentive to remain. So let's focus on what we actually know about the leaked evidence and the attorney response, because understanding the sequence and substance matters enormously. You see, the evidence leak apparently occurred over the weekend when documents were provided to major media organizations by sources described as having direct access to prosecution files. According to early reporting from multiple outlets, the leaked materials include communications that directly contradict statements Trump's attorneys had made in court filings and public statements. That contradiction creates the precise ethical dilemma that makes continued representation potentially impossible. Attorneys cannot knowingly allow false statements to stand uncorrected in court proceedings. When evidence emerges showing that representations made to courts were inaccurate, ethical obligations require either correcting the record or withdrawing from representation. The wholesale nature of the departure suggests attorneys concluded that correction was impossible without fundamentally abandoning defense positions, leaving withdrawal as the only ethically permissible option. In the past 48 hours, we've seen not just attorney departures, but the emergence of evidence descriptions that legal experts are characterizing as potentially case-defining. You see, multiple sources familiar with the leaked materials report that they include contemporaneous communications showing Trump's awareness of facts he has publicly denied knowing. From a legal standpoint, such evidence is extraordinarily powerful because it eliminates defenses based on lack of knowledge or intent. From a defense attorney's perspective, evidence proving client knowledge of key facts creates nearly impossible strategic challenges. When prosecutors can prove through the defendant's own communications that denials were false, the space for effective legal defense contracts dramatically. When leaders are shown through their own words to have known what they publicly claimed not to know, we move from disputed facts subject to interpretation into documented falsehoods that destroy credibility on all contested issues. Alongside the communications evidence are reports of financial records that allegedly show transactions contradicting Trump's characterizations of various business dealings central to criminal charges. The forensic nature of financial evidence makes it particularly difficult to challenge. You see, bank records, wire transfers, and documented payments create objective proof that exists independent of witness credibility or memory. When financial evidence directly contradicts defendant explanations, defense attorneys face the challenge of either attacking documents that are inherently reliable or acknowledging that client accounts were inaccurate. Neither option provides viable paths to successful defense, particularly when multiple independent financial institutions' records tell consistent stories that contradict client narrative. Now, legal ethics experts and former prosecutors have been analyzing the attorney departures, and several elements stand out as particularly significant indicators of what triggered such comprehensive collapse. Let me walk you through what makes this situation different from typical attorney-client disputes, because understanding the distinctions matters for assessing what comes next. You see, the first critical element involves the apparently sudden nature of the departures following evidence disclosure. Attorneys who had vigorously defended Trump for months reached withdrawal decisions within days of evidence becoming public. That compressed timeline indicates the evidence revealed information that fundamentally altered professional calculus in ways that made continued representation immediately untenable rather than merely more difficult. Regardless of one's perspective on the underlying case, professional responsibility rules that govern attorney conduct are well established. They require candor to tribunals, prohibit knowing assistance in client fraud or perjury, and mandate withdrawal when continued representation would violate ethical obligations. You see, the speed and comprehensiveness of departures suggest that attorneys concluded leaked evidence made compliance with those obligations impossible while maintaining client relationship. The concern extends beyond any single piece of evidence to what appears to be systematic undermining of defense positions attorneys had advanced. It addresses whether attorneys can continue representing clients when evidence shows that court filings and arguments were based on factual premises that leaked materials prove false. You see, when prosecutors can demonstrate through leaked evidence that defense theories rest on provably inaccurate factual claims, attorneys face impossible choices. They can withdraw from representation, which protects professional standing but abandons clients. They can attempt to advance new theories not dependent on contradicted facts, which may be strategically impossible if alternative defenses don't exist. Or they can continue pressing discredited arguments, which violates ethical obligations and risks professional sanction. The wave of withdrawals indicates attorneys concluded the first option was the only professionally survivable choice. There's a well-established framework for how attorney withdrawals should proceed. particularly in criminal cases where defendants' constitutional rights to representation must be protected. It requires court approval, demonstration that withdrawal won't unduly prejudice the client, and typically some explanation of the reasons necessitating withdrawal that doesn't breach attorney-client privilege. But in this case, according to court filings that are becoming public, attorneys are seeking emergency withdrawal approval and citing professional responsibility concerns that courts are apparently finding sufficient to grant rapid approval. That judicial acquiescence to compressed withdrawal timelines, despite the prejudice it creates for Trump's defense, suggests that judges reviewing confidential explanations attorneys provide understand the ethical dilemmas are genuine and serious enough to override normal protection against mid-litigation counsel changes. To be absolutely clear, and this remains important, attorney withdrawal doesn't prove client guilt or even establish that everything in leaked evidence is accurate. You see, ethical obligations require withdrawal based on attorney knowledge and belief, which may be based on incomplete information or prove mistaken upon fuller development of facts. Attorneys can have good faith beliefs about ethical conflicts that don't ultimately reflect reality. But the decision by multiple experienced attorneys to withdraw simultaneously reflects shared professional judgment that continued representation crosses ethical lines they cannot traverse, regardless of whether that judgment proves entirely correct. That collective assessment by practitioners with direct access to both client and evidence provides powerful indication that the professional dilemmas are real and serious, even if specific details remain subject to legal dispute. According to sources familiar with the withdrawal filings, one particularly significant element involves what attorneys characterized as discovery of prior misrepresentations to counsel. You see, attorney-client relationships depend fundamentally on client honesty with their lawyers. When clients lie to attorneys about material facts, it compromises the entire representation because attorneys cannot provide effective counsel based on false information. More critically, when attorneys discover they've made representations to courts based on false client information, ethical obligations require correction or withdrawal. If leaked evidence revealed to attorneys that clients had systematically misrepresented facts attorneys then incorporated into court filings, it creates the precise scenario that makes continued representation ethically impossible. The attorney hasn't personally engaged in fraud, but continued representation knowing that past court statements were based on client lies would make the attorney complicit in ongoing deception of the tribunal. The legal framework governing attorney withdrawals in criminal cases reflects tension between protecting defendants' constitutional rights and maintaining integrity of legal representation. Courts generally disfavor mid-trial withdrawals that might prejudice defendants or delay proceedings. You see, that judicial reluctance to approve withdrawals makes the apparent willingness to grant emergency withdrawal requests in this case even more telling. For courts to prioritize attorney ethical concerns over defendant prejudice and continuity of representation indicates that judges reviewing confidential withdrawal explanations concluded the professional responsibility issues were flawed, sufficiently serious that forcing attorneys to continue representation would itself threaten judicial process integrity. Under professional responsibility standards, courts can deny withdrawal motions unless ethical obligations make continued representation impossible. The approvals being granted suggest courts have determined this meets that stringent standard. An emergency hearing was reportedly convened to address the withdrawal requests and the resulting representation gap that leaves Trump without counsel in active criminal proceedings. You see, defendants in criminal cases have constitutional rights to representation that courts must protect. When attorneys withdraw en masse, it creates serious questions about whether the defendant can receive fair trial if unable to secure replacement counsel, or if replacement counsel cannot adequately prepare given compressed timelines. Federal judges managing complex criminal cases understand these dynamics and typically work to ensure representation continuity. For the court to accommodate mass withdrawals despite these concerns indicates judicial determination that forcing attorneys to remain posed greater threats to judicial integrity than the disruption withdrawals create. Let me clarify what these attorney departures mean in practical terms for the criminal proceedings, because the legal mechanics matter for understanding what happens next. You see, Trump now faces the challenge of securing new legal representation while criminal cases proceed on established timelines that generally won't be delayed indefinitely to accommodate counsel changes. Experienced criminal defense attorneys understand that taking over mid-litigation places them at significant disadvantage, inheriting strategies and record they didn't create while facing prosecutors who have been preparing for months or years. That disadvantage makes the representation less attractive to top-tier attorneys, even without considering the ethical issues that drove prior counsel to withdraw. The combination of mid-case entry difficulty and apparent ethical landmines in the representation may make securing qualified replacement counsel extraordinarily challenging regardless of Trump's ability to pay premium rates. The court must balance multiple competing interests in managing this situation. Defendants' constitutional rights to representation must be protected, but those rights cannot be used to indefinitely delay proceedings through strategic counsel changes. Attorneys' ethical obligations must be respected, but wholesale team departures cannot become mechanism for avoiding difficult representations whenever convenient. Judicial process integrity must be maintained, but proceedings must also be fair to defendants who may face representation gaps through no fault of their own. You see, that balancing act will play out in coming days as courts determine how much delay is warranted to allow Trump to secure new counsel and how much preparation time new attorneys require before proceedings can fairly continue. How courts resolve these questions will significantly affect both the timeline and the quality of defense Trump receives going forward. According to legal experts monitoring the situation, the combination of attorney departures and leaked evidence creates prosecution advantages that extend well beyond the immediate courtroom impact. Multiple commentators note that attorneys willing to take over representation now understand that prior defense theories were abandoned as untenable when evidence emerged. That knowledge constrains what new counsel can plausibly argue without simply recycling approaches that prior attorneys concluded were professionally impossible to maintain. You see, this limits strategic flexibility and may force defense approaches that are legally permissible but strategically suboptimal because better strategies were foreclosed by evidence developments and prior counsel conclusions about what ethical representation permits. Here's the deeper institutional dynamic that extends beyond this specific case, and this is critical to understand from a systemic perspective. You see, if attorney departures driven by leaked evidence become a pattern in high-profile cases, it creates troubling incentives around evidence disclosure and attorney ethics. Prosecutors who leak damaging evidence know it may trigger defense attorney withdrawals that severely prejudice defendants regardless of whether leaked material is ultimately admissible in trial. That creates potential for prosecutorial abuse where leaks are used as tactical weapons to destroy defense teams rather than merely to inform public. Conversely, if attorney ethical obligations don't compel withdrawal when evidence shows prior court representations were false, judicial process integrity suffers and attorneys become complicit in deceiving tribunals. Both outcomes create serious problems. We need legal frameworks that protect both attorney ethics and defendant rights without allowing either concern to be manipulated for improper advantage. If this pattern of evidence-triggered mass attorney withdrawals becomes normalized, American criminal defense practice faces fundamental challenges. What was a system where zealous advocacy within ethical bounds was expected would become something different, where attorneys must constantly evaluate whether continuing representation creates personal professional risk that overrides duty to clients. You see, That transformation would make representation of unpopular or factually challenged defendants increasingly difficult to secure, regardless of constitutional guarantees. In societies where this dynamic takes hold, it effectively creates two-tiered justice systems, where powerful defendants with sympathetic facts receive vigorous representation, while those facing strong evidence find themselves functionally unable to secure counsel willing to challenge prosecution regardless of constitutional rights. That's not the direction American justice should move, but preventing that outcome requires careful management of how attorney ethics, evidence disclosure, and defendant rights interact in high-stakes cases. The political implications of defense team collapse parallel, but extend beyond the legal consequences. Within hours of attorney departures becoming public, political observers began analyzing how these developments affect Trump's political standing and electoral prospects. You see, presidential candidates facing criminal trials without legal representation create unprecedented scenarios that American political culture has no established framework for processing. Republican primary voters must now evaluate whether supporting a candidate who apparently cannot maintain legal counsel due to evidence-driven ethical conflicts serves their political interests. General election voters, if Trump secures the nomination, face similar calculations about whether they're comfortable elevating to the presidency someone whose legal team resigned en masse when confronted with damaging evidence. By the first evening after mass departures became public, polling firms began surveying whether the developments affected voter perceptions of Trump's legal situation. You see, previous legal challenges Trump faced often strengthened support among his base, who viewed prosecutions as political persecution. Whether attorney departures driven by leaked evidence produce similar rallying effects or instead undermine confidence by suggesting that even Trump's own lawyers concluded his position was indefensible remains uncertain. The political impact depends significantly on how effectively Trump can message around these developments and whether replacement counsel can be secured quickly enough to prevent extended period of appearing legally abandoned. Public opinion formation around complex legal developments occurs gradually and unevenly, especially in our current fragmented media environment. Some Americans will interpret attorney departures as confirmation that Trump's legal position is indefensible and that even highly paid lawyers concluded representation was professionally impossible. Others will view the same events as evidence of prosecutorial misconduct through strategic evidence leaking designed to sabotage Trump's defense. The nation, already polarized, will likely process these events through existing interpretive frameworks rather than allowing evidence to reshape prior conclusions. But here's what concerns me most as someone who has watched legal and political institutions interact for nearly a century. You see, we're approaching circumstances where major legal developments affecting democratic processes no longer create any common factual foundation for collective evaluation. When defense attorney mass withdrawals can be interpreted as either proof of defendant guilt or proof of prosecution corruption, depending entirely on prior political commitments, we've lost the shared epistemological framework necessary for democracy to process contested information and reach collective judgments. The very fact that leaked evidence was apparently damaging enough to trigger comprehensive legal team collapse, that multiple experienced attorneys simultaneously concluded continued representation violated professional obligations, and that courts approved emergency withdrawals despite the prejudice to defendant, tells us something critical about the severity of the underlying situation. You see, these are not normal litigation developments subject to routine explanation. They're signals that people with direct access to evidence and intimate knowledge of client interactions have made extraordinary professional decisions that carry significant career and reputational costs. From my experience evaluating institutional behavior across business and civic contexts, when professionals abandon lucrative engagements and accept the reputational damage that accompanies mid-representation withdrawal, it reflects calculation that staying posed even greater professional risks than the considerable costs of leaving. Whether you follow legal proceedings closely or prefer to maintain distance from daily developments, structural failures in legal representation affect everyone who depends on justice system integrity. They affect confidence that legal processes can fairly adjudicate disputes regardless of defendant power or popularity. They affect belief that professional ethics still constrain attorney conduct even in highest stakes representations. They affect trust that evidence matters more than political loyalty in determining legal outcomes. You see, when legal representation collapses in the most prominent case in the nation, it sends signals about legal system health that extend far beyond the immediate parties to affect public confidence in justice as an institution. These aren't abstract concerns for legal scholars. They translate into whether ordinary Americans believe the legal system operates fairly or has become hopelessly politicized in ways that make outcomes depend on power rather than facts. At its core, this is a stress test of whether American legal institutions can maintain integrity when facing maximum political pressure and evidential complexity. You see, can attorney ethical obligations still constrain conduct even when clients are politically powerful and willing to pay premium fees? Can evidence still drive professional decision-making even when acknowledging evidence strength creates political controversy? Can courts manage cases fairly when representation collapses and replacement counsel may be difficult to secure? Can the public evaluate legal developments based on evidence and professional judgments rather than purely through partisan interpretive lenses? I've always believed institutions reveal their true character under maximum stress. We're discovering what American legal institutions are actually made of when tested by circumstances that strain every assumption about how representation, evidence, and professional ethics interact. This is not merely dramatic development in one legal case that will be resolved and forgotten. It's a defining moment for how American legal culture manages the intersection of criminal defense, attorney ethics, and political consequence. You see, if professional responsibility obligations can compel attorney withdrawals even from the most prominent representation imaginable, when evidence creates ethical conflicts, it validates that professional ethics remain meaningful constraints on attorney conduct, regardless of client power or compensation. If courts can fairly manage resulting representation challenges while protecting both defendant rights and judicial integrity, it demonstrates that legal institutions can adapt to unprecedented circumstances while maintaining fairness. If these things prove impossible, if professional ethics collapse under political pressure or courts cannot manage fair proceedings when representation fails, it suggests American legal institutions are more fragile than constitutional rhetoric suggests. But if this moment demonstrates that evidence still matters enough to drive professional decision-making, that ethical obligations constrain attorney conduct even when inconvenient or costly, and that legal processes can continue functioning even when political pressures are overwhelming, we validate something essential. You see, we demonstrate that the legal system operates according to principles that transcend individual cases or political consequence. We show that attorney ethics are real constraints rather than aspirational suggestions that yield whenever client power or payment is sufficient. And in the long term, that validation matters more than any individual case outcome, because it either confirms or invalidates the entire premise that American justice rests on professional integrity and evidence-based decision-making rather than merely power and political alignment. When legal professionals make career-altering decisions in highly visible contexts, it sends signals extending far beyond immediate cases. You see, it tells future attorneys whether ethical obligations are enforced even when compliance is costly, whether courts support professional responsibility even when it disrupts proceedings, and whether the profession maintains standards that occasionally require personal sacrifice to uphold. It tells clients whether attorneys can be pressured to ignore ethical obligations through sufficient payment or political influence, or whether professional responsibilities ultimately limit what attorneys will do regardless of inducements. It tells the public whether the legal profession maintains integrity or has become purely mercenary, willing to advance any argument and ignore any ethical constraint if compensation is adequate. These signals shape how all future high-stakes litigation proceeds and whether legal profession maintains public legitimacy as honest broker in adversarial process. The consequences extend beyond legal proceedings to affect political culture and public trust in institutions broadly. Uncertainty about whether legal representation can be maintained when evidence is strong affects public confidence that legal processes can hold powerful figures accountable. You see, if even wealthy defendants facing serious charges cannot maintain representation when evidence contradicts their positions, it suggests that professional ethics still function as meaningful constraints. Conversely, if representation proves impossible to secure because ethical attorneys won't participate but proceedings continue anyway with inadequate counsel, it raises serious fairness concerns that undermine confidence in verdict legitimacy regardless of outcome. Countries with dysfunctional legal systems, where either ethics are routinely violated or representation becomes unavailable for unpopular defendants, pay measurable costs in diminished public trust and social cohesion. The United States has largely avoided those dynamics through professional integrity and strong attorney ethics enforcement. Testing those foundations under maximum stress reveals whether they're genuinely robust or merely function during easier times when compliance is less costly. The landscape remains fluid with new developments emerging. You see, additional evidence may continue leaking as various actors pursue strategic advantage through selective disclosure. Trump may or may not succeed in securing replacement counsel willing to take over representation mid-litigation. Courts may grant or deny delays to accommodate representation transitions. Public opinion may shift based on how developments are messaged and processed through partisan media ecosystems. Each development creates new pressures and decision points where legal professionals, judicial officers, and political actors must choose between competing obligations and interests. How those choices accumulate determines whether this becomes moment of legal system validation or exposure of terminal institutional dysfunction. But let's maintain realistic perspective about alternative scenarios. There's genuine possibility that Trump secures capable replacement counsel who develop effective defense strategies not dependent on contradicted factual premises. You see, new attorneys, unburdened by prior representations, might identify defense approaches that departed counsel never pursued. Different lawyers might evaluate ethical obligations differently and conclude that continued vigorous defense remains possible within professional bounds. Courts might grant substantial delays, allowing new counsel adequate preparation time. Any of these developments could transform current crisis into temporary setback rather than permanent collapse. The appearance of complete defense failure might prove misleading if replacement counsel emerge quickly and effectively. We should avoid premature conclusions while situation remains fluid and subject to rapid change. What matters in coming weeks is not just whether Trump secures legal representation, but whether the episode produces any collective learning about institutional health and systemic sustainability. You see, do we recognize that evidence leaking, whatever its source or motivation, creates serious fairness and process concerns that ought to be addressed regardless of whether it helps prosecution in individual cases? Do we understand that making criminal defense representation professionally impossible through ethical conflicts or leaked evidence, even when defendants are unsympathetic, threatens fair trial rights that protect everyone? Do we acknowledge that political polarization has reached levels where even straightforward professional decisions like attorney withdrawals get processed entirely through partisan interpretive frames that prevent any shared factual assessment? These questions will be answered through how legal institutions, media organizations, and millions of individual citizens respond to and process these developments in coming weeks and months. Whatever unfolds will be examined by future generations as critical data point in evaluating American legal culture during period of extreme political stress. You see, they'll study how attorney ethics functioned when tested by high-stakes representation, how courts managed when representation collapsed mid-litigation, and how public processed evidence of professional decision-making. They'll evaluate whether institutions maintained integrity under pressure or whether political considerations overwhelmed professional obligations and fair process requirements. They'll judge whether evidence-driven attorney decision-making was respected or attacked based purely on whose interests it served. That evaluation will be informed by evidence we cannot yet see fully and developments we cannot predict. That's the burden of living through consequential moments. You see, decisions get made without benefit of historical perspective that later generations will possess. We're all stakeholders in how this unfolds, regardless of political affiliation or personal views about Trump. You see, whether we're legal professionals concerned about maintaining ethical standards, business people who depend on stable legal frameworks, or citizens who rely on justice system integrity to protect rights and property, the health of legal institutions provides foundation beneath everything else. When legal representation becomes impossible to maintain, when evidence leaking sabotages defense preparation, when courts struggle to manage fair proceedings because representation has collapsed, the entire system's capacity to deliver just outcomes comes into question. When that capacity is doubted, every legal proceeding becomes suspect, and every outcome becomes subject to challenge based on process failure rather than merits. That's why these developments matter to everyone, not just Trump supporters or opponents. It's why I'm addressing this situation despite preferring to avoid political controversy and focus on financial markets, where my expertise lies. The immediate path forward depends on whether replacement counsel can be secured, whether courts grant adequate time for preparation, whether additional evidence emerges, and whether public opinion crystallizes in ways that affect political and legal calculations. You see, these are not predetermined outcomes, but rather contingent results that will emerge from countless individual decisions made by attorneys evaluating whether to accept representation, judges balancing competing obligations, prosecutors deciding charging and trial strategies, and citizens forming judgments about what evidence and professional decisions reveal. How all those individual choices aggregate determines whether American legal system demonstrates resilience and integrity or exposes dysfunction that political stress reveals but didn't create. The developments of recent days are not abstract legal technicalities, but concrete evidence about institutional health and systemic capacity. They're official professional decisions by experienced attorneys who concluded that ethical obligations made continued representation impossible. They're court approvals of emergency withdrawals despite serious prejudice to defendants' constitutional rights. They're leaked evidence apparently damaging enough to trigger wholesale legal team collapse. You see, these are facts about institutional behavior and professional judgment that exist independent of partisan spin or political preference. The question is whether we can still evaluate such facts based on what they actually demonstrate about evidence strength and ethical constraints, or whether political identity has become so dominant that even professional decisions get absorbed into partisan warfare without possibility of shared assessment. This is not primarily about Trump as individual defendant, though obviously his legal jeopardy is directly at stake. It's about whether legal system that must outlive any individual case can still perform basic functions of providing fair representation while maintaining professional integrity. It's about whether attorney ethics remain meaningful constraints or have become optional guidelines that yield under sufficient political or financial pressure. It's about whether evidence still drives professional decision-making or whether decisions are purely strategic without regard to ethical obligations. In business, I've always emphasized that reputation and integrity are assets that take decades to build and moments to destroy. You see, the same principle applies to legal institutions. Professional integrity that took centuries to establish can be lost quickly if ethical obligations stop constraining conduct or if fair process becomes impossible when defendants are politically prominent. We're testing whether those foundations are solid or merely appeared solid because they were never truly stressed. Listen, I've observed legal institutions navigate extraordinary challenges over 94 years. You see, I've seen cases that tested professional ethics, circumstances that made fair representation seem impossible, and moments when political pressure threatened to overwhelm legal process. But I've also seen the legal profession maintain integrity when commitment to professional values was tested, seen courts protect defendant rights even when unpopular, and seen evidence ultimately drive outcomes despite enormous political stakes. This moment feels different in the comprehensiveness of defense team collapse and the velocity with which it occurred. Our collective capacity to process such developments through shared factual framework appears compromised, perhaps beyond repair. Our willingness to respect professional ethics decisions, even when they serve interests we oppose, seems uncertain. You see, what happens now will define whether American legal culture can maintain integrity under maximum stress, or whether political polarization has damaged institutional foundations beyond recovery. That's enormous responsibility falling on legal professionals who must decide whether to accept representation, judges who must balance competing obligations, and citizens who must evaluate evidence and professional decisions. The institutions we inherited aren't ours to abandon when they produce unwelcome results or constrain preferred outcomes. You see, they're ours to protect and strengthen even when maintaining them is costly or inconvenient. If we fail that duty, if we allow professional ethics to be dismissed as obstacles when they constrain our political allies, the degradation affects everyone because institutions weakened for temporary advantage provide weakened protection when we need them against future threats we cannot yet foresee. So pay attention to how legal institutions manage these challenges. Evaluate whether professional decisions are respected or attacked based solely on whose interests they serve. Consider whether evidence developments and ethical constraints matter, or whether outcomes are predetermined by political identity regardless of facts. Remember that fair process protections you want when your interests are at stake are the same protections others deserve when their interests conflict with yours. You see, that reciprocity is the foundation of legal legitimacy. Destroy it for temporary advantage, and you'll find yourself without protection when circumstances change. In any system worth preserving, silence when institutions are tested is a choice. You see, and sometimes it's the most expensive choice because silence allows erosion to continue until restoration requires more commitment than society's retained capacity to provide. Before I close, if this analysis has helped you understand these complex developments and their implications for legal institutions we all depend upon, please take a moment to like this video and subscribe to the channel. Your engagement helps ensure this kind of independent perspective remains available as events continue unfolding. Thank you for your time and attention to matters that will define whether American legal institutions maintain integrity under pressure or reveal fragility that political stress exposes. The Republic asks that citizens pay attention when institutions face defining tests and care enough to defend principles even when politically inconvenient. That's modest price for legal protections we've inherited and obligation we bear to preserve them for future generations.